Hello viewers, today we are going to discuss about Indian copyright law. This topic has a huge impact in today's scenario. In this topic, we will be discussing about definition aspect, what all it includes, what are the series of assets which are included in Indian copyright law. It also includes the exemptions given to the assets which should not be governed by Indian copyright law. In administrative provision, we will be discussing about the steps which are required to register a copyright. We will be also discussing about the penalties when somebody violates the copyright. As you can see in the picture, the copyright is depicted with a C in a circle. If any asset, any website, any blog is copyrighted, it will be depicted with a circle in C. If you see that symbol, you should not copy that content without the permission of the author. If we discuss the definition of copyright, it means it is an intellectual property law which protect your socio-economic and legal interest when you create a work. When we discuss the list of assets which this copyright law govern, it has a classification. It starts with original, literary, dramatic, musical and artistic work. It includes cinematograph films and sound recording. Computer software is a special category under Indian literary work. It includes computer program, tables, codes, etc. It also includes the websites if the content are copyrighted. It also includes blogs and e-books, which has a huge impact in today's scenario. Let us focus with an example what will be the impact of copyright. We have taken the example of a literary work. Once we register under copyright the literary work, you have a full claim to reproduce the work. You can also issue copies of the work to the public at large. You can also do a public performance work in the public. You can also communicate the work to the public. You can make cinematograph film or sound recording in respect of the work you have done. You can also make translation of the work. You can also make adaptation of the work. So, by example, we are going to discuss one by one. For example, you have written a book and then you have the original claim to do drama work from that book. You have the original authority because it is your work, the book is your work, and if somebody want to broadcast the drama from your work, the person has to take your permission. Now, we cannot copyright everything. Government of India has exempted certain series of work which you should be exempted, so that it can benefit the society at large. There are certain examples of such kind of exemption. A first exemption is for the purpose of research or private study, you can refer the research study of someone else. You can also refer someone else's work for criticism or review. It won't be accounted under violation of copyright. For journalist reporting of current event, convenience, copyright things has given the exemption. For judicial proceedings also copyright exemptions are given. For the reproduction of few copies for use in libraries or for research for private study, copyright exemption is granted. For the matters published in official gazette, including Act of Parliament, subject to certain conditions, are exempted from copyright violation. If somebody perform by an amateur club or society, if the performance is given to non-paying audience, the best example, if the students are performing in university program and they use someone else's lyrics, but as it is for non-profit purpose, it will be exempted from copyright violation. Till now, we have discussed the definition in detail and the exemptions are granted, but we have to be very much clear about what are the broad categories of rights which a copyright protects. If we see, there are primarily 5 kinds of right which the Copyright Act protects. The first right is right to reproduce work. The example is, if some director has made a movie and the movie is a huge success and director want to make that movie again in a series 1, series 2, for example, Dhoom 1, Dhoom 2. So, the creator has the right to reproduce that work. Some other director cannot reproduce Dhoom 2 from Dhoom 1 if the person does not take permission from the original creator. Second right is right to adaptation and translation of work. If I have made a book, I have written a book and it is a huge success and the same work is demanded in the South language, for example, Malayali language, then I have the translation right. If I authorize somebody, then only that Malayali translation is possible, otherwise not possible. The third right is right to distribution copies of work for a commercial rental. This also originally rests with the original creator. Now, right to public performance is the fourth right. For example, if I have written a poetry, then first right for public performance will be my right. If someone else want to recite those poetry in public performance, they have to take my permission, otherwise it will be the violation of Copyright Act. The last right is right to broadcast work. If somebody television production company has made a beautiful serial, then it is their right to broadcast work. If somebody want to show that work, they have to take the permission from broadcast company with the help of a commercial agreements. Very common question which we face, a creator is not generally aware about whether to register the copyright or not, or whether it is compulsory to register a copyright. The simple answer to this question is, it is not compulsory to register your creation, but it is always advisable to register with the Government of India. The reason is very simple. If someone else has copied your work and the person claim your work as his or her work, then you must have a proof, and that proof is registration under Indian Copyright Act. That is why it is always recommended, if you create something like music, like choreography, like a website, like a software, you should copyright it. And the best part is, even you can copyright your unpublished work. Even if we plan to start the work, you can copyright it before publication of that work. Now the next question arises, what is the procedure for registration of Copyright Act? Indian government has given a detailed law, Indian Copyright Act 1957, and Indian government has made very nice user friendly steps of copyright registration online. You can simply browse to the www.copyright.gov.in. The registration mode is in two ways, first is manual and second is online. You can see the website, there is a online registration procedure and a detailed diagram, the data flow diagram, which shows the registration procedure. You have to go through this data flow diagram and follow these steps. The typical time taken to register you is generally 30 days and it may extend to 3 months. What happens when you apply for the registration? An e-token number is generated, and when e-token number is generated and your work is registered, it is shown to the audience. Somebody can take the objection against your work. If there is a complaint against you before registration, the board, the dedicated authority, listen to those complaints and decide in favor of whose copyright should be given. Generally, it takes from 30 days to 3 months to publish the copyright certificate in your favor. The general question is, when we register a copyright, then what will be the duration till how long we can enjoy? As per the rule, you generally enjoy copyright for 60 years. You enjoy that entitlement for 60 years and you can take commercial and legal advantage of being the owner of copyright. After discussing the procedure about the registration of copyright, let us discuss about copyright violation in legal parlance. The exact word of copyright infringement is in common parlance is known as piracy. The copyright infringement means unlawfully copying someone else's work which is protected by the law. Copyright infringement is a huge offense and very common nowadays after onset of web revolution. People copy each other blogs, research work and they represent them as their own work, which is against the law. There are enlisting of offenses as you can see in the picture, which accounts for infringing copies. Let us start these acts one by one. The first is making infringing copies for sale or hire. You cannot sell the original creator's work illegally without his or her permission. The second is making public performance without taking the permission. If somebody has written a beautiful poetry and you are claiming it as your poetry and performing in the public in a concern, it is the violation and it accounts as the piracy, and in legal parlance it is known as copyright infringement. Distributing infringing copies for trading is again an offense under this category. Public exhibition of infringing copies, for example, if somebody has made a painting copying from a famous author's painting and the person exhibit publicly and makes money out of it, this is a clear cut violation and it accounts to the piracy under this act. In international parlance, importing of infringed copies in India is again prohibited in law. Somebody cannot set a free that the person lives in the foreign. There are so many interesting cases in India and abroad. I will be discussing one case of India and one case of foreign country. As you know, the very famous country Apple, very famous company Microsoft, both of them had a copyright issue on GUI, that is graphic user interface. Apple claimed, Apple filed a suit on Microsoft for using the GUI originally developed by Apple. In a copyright case, finally the case was in favor of Microsoft, and few products where few copyrighted was claimed by Apple and majority of copyright was claimed by Microsoft. The second case was of India, where a famous movie director Madhur Bhandarkar, who was producing the fashion movie at that time, one of the authors Seema Seth has accused Madhur Bhandarkar of copying his book and made the movie fashion out of it. And there was a long battle in the court, and at the last the case was dismissed against Madhur Bhandarkar, and this is a very famous case, and it is very common on movie script. People claim that a script belongs to them, but after legal fight there is a financial settlement and the cases are resolved. With this, there is a dire need to know what are the authorities established under the Copyright Act, who will be resolving such dispute. The first authority is registrar under Copyright Act, which register you and issue you the certificate of registration. The main body is Copyright Board. Copyright Board is the central body constituted under Copyright Act for the discharge of certain judicial function. There is a chairman, chairman can be 2 or more, and there are members not exceeding 14 in this Copyright Board. The registrar perform all secretarial function of Copyright Board. The board here appeal against the order of registrar of copyright. If somebody complain against registrar, board decide whether the complaint is right or not. The Copyright Board will be deemed to be the civil court under this act. They have the power of civil court to decide whether a work has been published or as to is on the date on which the work was published. The board has the authority. Board primarily settle the dispute arising in respect of assignment of copyright. This is to mention that the chairperson of the board is High Court judge or the person who has been a High Court judge. So, it is a very significant legal body. Now, if somebody is charged about copyright infringement, what will be the remedies against the person who want to sue? There are primarily 3 kinds of remedies. The first remedy is civil remedy, the second criminal, and third is administrative remedy. When we discuss the civil remedy, if somebody has violated the copyright against me, I can plead for civil remedy to the district court in whose jurisdiction the dispute has happened. I can ask for injunction damage or account of profit. Injunction damage means I can appeal to the court to pass injunction against the person who is using my intellectual property or copyright. I can also request to calculate the profit loss which I have incurred and to return me the same. The delivery of infringing copy and damages for conversion is also calculated so that I can make up my loss. Second is criminal remedy. Imprisonment and fine is the primary thing which I can claim. Under this there is certain amendment also. Let us start with unamended provision. Imprisonment of accused or imposition of fine both can happen. For the first time offender, imprisonment for 6 months or minimum fine of rupees 50,000 is administered by the judge. For the second offender, second time if the same person is doing copyright violation, the imprisonment is for 1 year and fine is rupees 1 lakh. Under amendment for the special category of crime for computer software piracy, section 63B has been inserted, and it states that any person who knowingly make use on a computer of an infringing copy of a computer program shall be punished with imprisonment for a term which shall not be less than 7 days, but which may be extended to 3 years, and with fine which shall not be less than rupees 50,000, but which may extend to rupees 2 lakhs or both. And at the same time the copies of infringing copies will be seized, and those infringed copy will be given to the original creator. Third category is administrative remedy. Administrative remedies consist of moving the registrar of copyright to ban the import of infringing copies into India when the infringement is by way of such importation. This is in case of international copyright, international way of exchanging the assets illegally, and the delivery of the confiscate infringing copies to the owner of copyright and seeking the delivery. Now, the question arises, who is responsible for copyright offence committed by a company? If individual has not committed the offence, but a company has involved into copyright violation, then the code says that every person who has the time when the offence was committed was in charge of and was responsible by the company for the conduct of business of the company, as well as the company shall be deemed to be the guilty of such offence and shall be liable to be proceeded against. Same penalty which I earlier discussed for individual will be liable to the person, for example, managing director, who is generally in charge of the all affairs of the company. Technical things are which court can try copyright offence cases. In case of in general the case civil and criminal cases, no court inferior to that of a metropolitan magistrate or a judicial magistrate first class shall try any offence under Copyright Act. There are certain role of police officer at the onset of complaint. Then the question arises, can a police officer seize infringing goods without warrant? And answer is definitely yes. A police officer not below the rank of a sub-inspector can seize without warrant all infringing copies of the work. Till now we have discussed majority of the issues regarding copyright law, but there are special cases arises. What in case when my copyright is violated abroad? How can I protect my copyright, because I am working as a blogger and anybody can copy my blog and make the money in USA and I am writing in India. So, there is a huge question mark. My money flow from USA is restricted, someone else is making on my behalf, violating my right. So, in that case India, we have to secure protection to Indian work in foreign countries. And to protect against these kind of violation in global level, India has become a member of various international convention on copyright and neighboring rights. We have to name these conventions. Let us see these conventions. The first convention we are member of is Berne Convention for the protection of literary and artistic work, Universal Copyright Convention, Convention for the protection of producers of phonograms against unauthorized duplication of their phonograms, Multilateral Convention for the avoidance of double taxation of copyright royalties, trade related aspect of intellectual property rights. These are the conventions where India is a member. And what happen if my right is violated abroad and India is a member of these convention and the member country where these rights are violated are also member, then my right is protected in that country same like it is protected in India, and vice versa. If a foreigner is in India and the foreign country belong to this convention, Indian government has to protect the right of that foreigner. The copyright violation of that foreigner happened in India. So, it is a vice versa agreement which protect copyright in global level. And in today's scenario, when we are operating in global level, we have to protect each other's right. Otherwise, we cannot operate global business and will be in a huge problem. Dear students, in the concluding part of copyright on information security and cyber forensics, we should be able to relate that now copyright in present world is focused on digital copyright, as most of the protected content are digitally available through online platform. To ensure you all about real exposure on this topic, let us have a view on leading cases on copyright law in cyber world. The first case is between Sega Enterprise versus Mafia. In this case, the plaintiff manufactured video games which could only be played on game console manufactured by plaintiff. The defendant managed a BBS service which enabled user to upload Sega games to his BBS, which could easily be downloaded by the users. The court took the view that defendants infringed plaintiff copyright as it caused infringement of the right of Sega Enterprise, which made efforts to develop game as well as console. Thus, case was decided in favor of Sega Enterprise as it was the plaintiff. Case number 2 is between Kelly versus Ariba Soft Corporation. In this case, Leslie Kelly copyrighted pictures which were displayed by a search engine that not only produced thumbnails, but also large size picture in his search result. This was held by the court to be an unauthorized reproduction of plaintiff's picture that directly infringed copyright of the plaintiff. While creating only thumbnail could be justified as a fair use, which gives the immunity from Copyright Act, but downloading from search engine result full size image amounting to an infringement of the copyright. This case was decided in favor of Kelly. The plaintiff, Kelly was the plaintiff in this case. In the next case, the case was between Microsoft Corporation versus Yogesh Popat. This is an Indian case. In this case, Delhi High Court dealt with a copyright infringement case and awarded compensation of rupees 23.62 lakhs to Microsoft Corporation against Compton Computers Private Limited and its director Mr. Yogesh Popat for uploading pirated software of Microsoft in assembled computers sold by the company. The next case, an international case, it is between Michael versus Internet Group Incorporation. In this case, court decided that it is the violation of copyright owner when someone makes available videotape over internet without authorization and posting an unauthorized copies of electronic clip art on the web pages. If a web designer create a website by combining some special feature of various websites, this may amount to unauthorized adaptation of the plaintiff software and violation of plaintiff copyright. In digital media, one can make infinite number of copies without loss of quality. So, the transferring data from one computer to another violate the reproduction right of authors. Thus, unauthorized reproduction of scanning a copyrighted printed document into digital file and uploading or downloading copyright file to a BBS is copyright infringement. My dear students, please be very careful when you do cut, copy, paste. You cannot copy and reproduce copyright protected material unless you have taken a formal permission in writing from the owner of the copyright. Let us finally conclude now. Today's session was highly useful as we were able to discuss various topics: definition of copyright, assets which are protected under copyright, registration procedure of copyright, rights enjoyed by copyright holder, and various authorities, offences and penalties if someone violates these provisions. My dear students, I also advise you to browse Indian government website www.copyright.gov.in for recent updates. Dear student, I hope you will follow copyright guideline in your work ethics. Thank you so much.